Thanks for coming, and welcome back to those of you who came before, and welcome to those who are new. And the good news is next time the IP workshop is going to be my partner, Dave Jaffer, so you'll get a break from listening to me. So today, last time we talked about forming your company, getting it started, founders agreements, and the like. And today we're going to talk about getting the money. So last time people asked questions as we went. I think that worked out pretty well. So if you have questions as we go, just raise your hand, and I'll try and answer them real time. Sure. Oh, you hear the questions? Okay. So I'll repeat the questions so everyone can hear them. There. Okay. She's in search of the handouts. The handouts today are a copy of the PowerPoint presentation. There's a bridge financing term sheet and a Series A financing term sheet. So let's see if I can make this work. Okay. So there's basically 5 types of financings for a startup company. There's bootstrap financing, which the concept is that you pulled yourself up by your bootstraps. And that's basically where you form a company and you just fund it yourself out of pocket until such time as you're ready to go out and get funds from other people. Your ability to do that, of course, depends on how much it costs and how much money you have personally. But that's what a lot of entrepreneurs do to get their company to a stage where they think they can interest other people in financing it. The next type is a bridge loan, which I'm going to get into more detail in a few minutes. Angel financing, VC financing, and the corporate investor. And for each of these additional 4, I'll cover them in more detail. Oops. Assuming I can work this. Okay. So a bridge financing is actually not the issuance of stock initially. It's a debt instrument. You're basically borrowing money from people, and you're issuing them a promissory note. You're doing that. It's a convertible promissory note that can be converted into stock in the future. And the reason that this is normally done is that maybe you're not raising enough money right now that you want to do a full-fledged Series A financing. Maybe you don't want to negotiate the price right now. Anything like that. It's usually done at the initial stages of a company, although sometimes it's done in between financing rounds. You maybe have had a VC financing and the company needs to get to another stage before it thinks it can go back into the market. The purpose of a bridge financing and why it's called a bridge is it's supposed to bridge you from one place to another. So when taking a bridge financing, you have to think about what the money's going to do for you. You need to bring in enough money to get you to the point where you can go out and do a financing. So perhaps you need to produce a beta product to show people. Maybe you want enough money to get a few customers so you can go out and market to VCs or angels. So you think in the beginning how much money you're going to need to get to the next stage, and that's the amount that you do for your bridge financing. The bridge financing is often done in a rolling method. Let's say you decide you need $500,000, but you don't have people lined up right now to give you $500,000, but you have 100 lined up. So you can take it serially, take 100 now, 100 later, until you get to the full 500. So the terms in a bridge financing usually are how much you're going to raise, how long you can go out and raise it under those terms. Because the people who put in the money today want to make sure that someone else who puts in money 6 months or a year from now, when there's not as much risk, doesn't get the same benefits they do. So that's something you have to negotiate with your investors. It usually has an interest rate because it is a debt instrument, but it's usually fairly low, maybe 3, 4, 5%. It converts into stock. Usually it's set up to convert into your next round of financing. So if you're doing it initially before the company has had any venture financing, it would convert into your Series A round. If you're doing it in between rounds, sometimes the bridge investor has a choice of whether or not they convert into the next round of financing, which would be your Series B round perhaps, or if they can convert back into the Series A. And they want the opportunity to make that choice once they see what the rounds are going to look like. Then also the conversion can be mandatory or it can be optional. If you're the entrepreneur and it's your company, you want it to be mandatory. You don't want to have to pay this money back in the future. You'd rather they convert into stock. If you're the investor, you'd rather have the choice. You'd rather be able to elect to have the stock or get your money back depending on how things pan out. So that's another item that gets negotiated. The term of the note is also heavily negotiated. Once again, if you're the company, you want that term to be as long as possible because you want to take this money in and you don't want to find yourself 6 months from now with a gun to your head having to pay back $500,000 that you don't have. You want to make sure that you get to keep this money and not have to pay it back until you've had a chance to take your company to a stage where you can raise additional funds. Also, the bridge investors usually get warrants, which warrants are a chance to buy stock in the future at a price that's set today. And the value of a warrant is that you don't have to part with any money today. You can wait until it's worth something in the future. And that's the benefit that the bridge investor gets for investing in your company early. Since the bridge investor usually converts into the next round of financing at the same price that's paid by other investors, you say, well, what's the good of that? The person who invested in the A round got that price, and the bridge investor who was there 6 months earlier got that same price. There wasn't really any benefit to the bridge investor. So that's why you do a warrant, so they have basically their upside. And warrants can range from 10%, 20%. I've seen them at 100%. It really depends on the market, the investor, how risky the company is. They can be very straightforward, just a straight 10%, or they can be complicated where they increase 5% every month if you haven't gotten financing. So say it starts out at 20%. If you don't have financing 3 months from now, it's 25%. 4 months from now, it's 30%, and so on. So that's something to be aware of when you're negotiating these instruments because you want to make sure that you don't end up giving away a much larger percentage of the company than you think you are. And then you also have to have some default provisions in your bridge term sheet. The concept is that this money will convert into your Series A round. Well, what happens if the Series A round never occurs? What does the person get? So that's something that you also have to negotiate. Often they might get common stock. Sometimes they simply get their money back. Sometimes they get a higher interest rate. But you have to think that through at the beginning. So there's a form of bridge term sheet that's in the handouts. Yeah. Usually they're not guaranteed. Sometimes they're secured, but usually they aren't. And the reason being that for the amount of money that you're raising, you don't want to give someone a right to all of your intellectual property and all the assets of the company. And bridge loans are very risky, and people pretty much know that when they make them. So bank lines tend to be secured, but not bridge loans. No. I mean, an investor could request that, but that's not the way it's normally done, and you'd want to try and avoid that. That's really the purpose of setting up your corporate entity, is to protect yourself from personal liability. Okay.
Given how risky they are, how come the multiplier ranges from 10% to 100%? Not above that.
I guess because there's enough investors that are willing to do it at that rate. And I would say, even 100% I don't see that often. It's usually no one's going to make a bridge loan if they don't have faith that the company's going to be successful. But you're right, they are taking a lot of risk there. Michael?
Is there usually a board seat in the case that it's external money from the investor? Is there a board seat usually associated with this type of financing arrangement?
There's not usually a board seat in connection with a bridge loan. There might be in some of the default provisions. They might provide that if you haven't paid the loan back by a certain period of time, the people can come in and control the board. But that's still pretty unusual, although you do see that sometimes.
A little bit more detail about the 10%, 20%. I missed what you're talking about.
Okay. So let's say you took in a bridge loan for $100,000. I need the easy math. So a 10% warrant would say that you take 10% of $100,000, which is $10,000. You divide it by the price of the next round of financing, Series A. So let's say it's $1. So it would say that warrant allows you to purchase 10,000 shares of Series A preferred stock for $1 in the future. Now, when the Series A round first closes, that's not really worth anything because you could just buy Series A stock for $1 right then. So the real value of the warrant is that you hold it for several years, and down the road, when now the stock is selling for $2, $3, $4, $5, you can buy the stock for $1. and then the percentages are just 10, 20, 30% of that. The warrant? Usually between 3 and 7 years. As the investor, you want the warrant to last as long as possible because its true value is in the future when the company has had some growth. As the company, you don't want these warrants hanging out there on your books for too long. So I would say in a raw startup, it would probably be at least 5 years and more likely 7. Okay.
What kinds of amounts of money would bridge financing typically be done for?
Probably anywhere from about 50,000 to maybe 500,000. A bridge that's in between series, so if you've done a A or a B and your inside investors are bridging you to the C, then it might be a couple million. But a bridge loan for a startup just getting started is probably up to about 500, maybe 750. Michael?
Can you tell us a little bit more about the default provisions and how likely is it that in the case of default, a company, if it falls apart, is there usually a lot of negotiation? What is that like? What are the alternatives usually?
Okay, I just remember that Linda had asked me to repeat the question. So the question is, in a default situation, is there usually a renegotiation or what basically happens? The reality is, if you've borrowed $500,000, you have a 1-year term, you get to the end of the term and you haven't raised any additional money, you don't have the money to pay them back. So usually what happens is the bridge lenders stay out there and they wait and hope that you raise additional money. Sometimes you might negotiate with them to extend the loan in exchange for additional warrants or something, a discount on the next series. But the reality is that there's not a lot the bridge lender can do if you don't have the money to pay them back.
What about in a situation where you can have a choice of, let's say, $500,000 of one internal loan, just of the current partners or investors, versus getting $500,000 for a bridge, like a rounding between.
The question is, what if you could get $500,000 internally from the founders or $500,000 for a bridge? That's really a choice that you need to make as founders. If you want to involve outside people and take their money, or if you want to spend your own money, or if you want to take some from both to, maybe hold your money for future needs. But there isn't really a right answer there. It's sort of whatever works best for the company. Michael?
Do investors who give bridge financings typically demand control or involvement in certain decisions and how that money is put to work and so on and so forth?
So the question is, do bridge investors usually demand control or oversight of the company or a say in how the money is used? Sometimes they do. Sometimes they stage their investment based on events. I'll lend you $100,000, but I'll give you $30,000 now to sign your lease. And when you enter into this contract with X, I'll give you another $20,000. So sometimes it is staged. Largely, it's given without a lot of conditions. And usually the bridge investors aren't too involved in the company management. They don't sit on the board. They don't have any rights to information or reports. But I will say the experience is you should try and limit your bridge investors to, say, a minimum of $25,000. If you take $5,000 here and $5,000 there, all my entrepreneurs tell me that the people who drive them the most crazy are the smallest investors. The guy who put $5,000 into the company is calling them every day, asking them for a status report, asking them how the company's doing, when there's going to be a financing. So it's a good idea, to the extent you can, to limit the investors, to make sure it's a significant enough investment that you're not dealing with a whole bunch of people. You also want to make sure that the people are sophisticated and they know what they're doing and that they have the money to lose. It is a security since it's convertible into stock, so you do have to comply with the securities laws and make sure that you're selling it to people that you're permitted to under the securities laws.
How do Series A investors feel about the existence of a bridge loan?
The question is, how does Series A feel about the existence of a bridge loan? Usually they don't have a problem with it. There are two ways that you can do a bridge loan. I didn't talk about the other way because they tend to have a problem. Sometimes the way they're set is, rather than having warrants, you get to convert into the Series A at a discount. So you can convert your bridge into the Series A at a 10% discount or a 20% discount or a 30% discount. For some reason, that's much more offensive to Series A investors than you having a warrant. And I think the thinking is that if I'm buying the stock today, I want to make sure you're paying the same price. If you have this warrant that may be of value sometime in the future, that doesn't bother me as much because we're both paying the same price. So our experience is that the warrants are generally accepted. The discounts usually get negotiated away. Sometimes the Series A investors will require that the bridge financing count against the pre-money valuation, and I'll get into pre-money valuation in a few minutes, but usually they don't.
That's actually linked to my question.
Okay.
In that case, wouldn't it be better if we just do a round before Series A, make Series A really Series B?
Well, you can certainly do that, but the reason that you might not want to is, first of all, you have to negotiate the price. So if you're raising $250,000, $500,000 in a bridge round, you don't really want to negotiate the price because often there's not one strong lead investor. There's a whole bunch of smaller investors. It's basically a way of punting. You don't have to negotiate the price right now. Also, you don't want to find yourself, by the time you're raising, your second or third round, you're already in your D or E or F round. So that's why a lot of people do a bridge. Plus, it's cheaper and it's quicker. You don't have to do as much paperwork and documentation. You don't have to create the Series A. But it is something that everyone thinks about when you're doing a bridge round. Should I be doing a bridge? Should I be doing a Series A? And a lot of it depends on how much you're raising, how soon you think you're going to be raising additional funds, and what the investors want. The question is, do people ever use it for raising friends and family money? They certainly do. I mean, sometimes bridge loans are friends and family. And that's a particularly good time to use it in that you don't necessarily want to be negotiating valuation with your friends and family. You can say to them, give me the money, we'll put it in a bridge loan. When the VCs come in, you'll get the benefit of everything they negotiate.
What is the transaction fees that are associated with the bridge loan?
What are the transaction fees associated with the bridge loan? Mainly legal fees. It's pretty much the drafting of the documentation, and there are some filing fees. There are some securities law filings that need to be made with the states. A securities law filing is made in the state where the investor is. So if you're selling stock in California to your friend in Illinois, you have to make sure you comply with the securities laws of Illinois. And all of the states, almost all of them make you file something, and almost all of them make you pay a fee. But they're usually ranging from $25 to a few $100. No, the investors do not usually take a fee. Sometimes people engage finders, someone to go out and help them find the money, in which case they might pay them a fee. And often that fee is in stock.
If one of the founders is putting in money, do they have a reason to prefer buying stock initially or doing a bridge?
So the question is, if a founder's putting in money, do they have a preference? Usually, it depends on how much the founders are putting in. And you wouldn't want to do a whole financing just for the founder unless the founder is putting in a few million or something like that. But it is a good idea if a founder is putting in a significant amount of money to put it in as a bridge along with other investors. Otherwise, if founders advance money along the way, usually when they get investment, the financing from a VC or a bigger Series A round, the investors don't want to see a lot of money going right back out the door to pay the founder back for expenses he or she's advanced in forming the company. So if you are putting in a significant chunk of change along with other investors, it's nice to do it in the same form as them so that you can convert that into stock.
If the finder is not a licensed securities broker, does that create problems later on?
That's a good question. If the finder is not a licensed securities broker, does that create problems? Now, it does if the person's not truly a finder. A finder is defined as someone who is paid a fee for helping you raise money whether or not they're successful. A broker-dealer is someone who helps you raise money and receives a percentage of it. So I'll pay you 2% for every dollar you raise for me. A broker-dealer does have to be registered, and if they aren't registered and they help you, you can have securities laws issues later. Okay, I think we should keep going to the next one. And if you have more questions, you can ask them at the end. So the next type is angel financing. And usually angel financing is less than $1 million, but more than a bridge loan. So with angels, you want to sell Series A stock, back to our example that you're just forming the company. And the terms are often similar to VC financing, which we'll get to in a moment, but usually they're not as difficult. The big issue with angel financing is to find someone to basically lead the round. What you don't want to do if you have a lot of angels investing is separately negotiate with each one of them. You want to try and find a lead angel who will set the terms, and then everyone will invest on those terms. And we can discuss terms more in a minute when we get to the VC financing rounds. So in the angel round, you want to make sure you have a lead investor. You want to make sure that you don't have too many investors, because you can run into the same problems with the bridge financings. And you also want to make sure that the angels aren't going to expect too much control from the company. Now, an angel round, usually someone will sit on the board. So what you want to do is make sure ahead of time you understand who that's going to be and who has the rights to elect that person. To find angel, there's not as many angels out there as there used to be in the boom, but there are several angels networks. There's the Angels Forum, there's the Band of Angels, there's the Angels Breakfast Club, and they range in how they operate. A lot of them have a breakfast, the Angels Breakfast Club, where you're invited and you present to all of the angels, and then they decide on an individual basis whether or not they want to invest in you. And one of the issues with that is you're sitting in a room full of people, you're disclosing your idea and your business plans, and you're trying to convince them to invest, but you don't really know who all is there, what their background is, what their interest is in what you're doing. So you need to be careful because you are disclosing it to a lot of people at once. The angels organizations work differently. Some of them will invite you in to present, and there's any chance whether or not you'll get funded by any number of them. Others have more of a screening process where they sort of have a back office. So you go through that screening process first, and then you're only invited to present if the back office feels that you have a good chance of being funded. That one's probably a little more promising. It's harder to get into those in the first place, but you have a better feel that if you present to them, you'll get some investment out of it. So the next is VC financing. Usually VC financing is over $1 million, usually significantly over $1 million. VCs usually like to invest at least a minimum of $3 million. And the reason being is the funds are so large that if they make too many small investments, they really can't give the time and focus that they want to give. There are VC funds out there, though, who focus on smaller investments. There are actually some funds who will invest as little as $500,000. But you need to think about that as you go to raise financing. How much do you need? And who are the most likely candidates? If you really only want to raise $1 million or $2 million, you don't want to go to a fund that's minimum investment is $5 million. So you want to do a little research before that. VCs often like to invest in PACs. They like to invest with more than one of them. And so what they will usually do is have a lead VC and then find others to join. One of the things you want to do is if you're talking to a VC and they say they want somebody else to join, you want to understand if they're going to go out and find that other VC for you or if you're supposed to do it. And obviously a VC who comes with money and brings the other investor is much more helpful than one who says, I'll invest if somebody else does. So you want to understand before you get too involved with them what the plan is for getting the additional investors. So the VC financing basically starts out with a term sheet negotiation. And in the materials that are passed out, there is a sample term sheet for you to look through. It doesn't have every term under the sun. It's just a general idea of the kind of terms that you will find. One of the questions that Michael had asked me to cover is, how long does it usually take to get VC financing? And we advise people that it usually takes 3 to 6 months to get VC financing. So it takes a long time. So you should be sure to allocate enough time to really complete the process. It also takes a significant portion of your time. You would think, well, why did I have a few meetings? How much time can that take? But you're constantly meeting with people, having follow-up meetings, having diligence meetings, finding the VCs that you want to talk with, polishing up your business plan. And so you should really keep in mind that it's going to take a lot of your time, and you need to be patient. And people many times go to 10, 20, 30 VCs before they find one to invest. So it can often be a very tedious process. We usually advise that you create the list of the VCs you want to approach, and then you have 10 in play at any time. You don't really want to do it one at a time because that just takes too much time. There's a joke that VCs never say no. They always say, that's really interesting, I'll get back to you. So you can't sit around and wait for the VCs to say no. You can't send your plan to one of them wait around for them to say no, and then when you finally hear no, go to the next one because you'll be raising money for the rest of your life. On the other hand, you want to be careful that you don't overshop your plan. You don't want to send it out to 100 VCs and have everyone think, you're all over town. Plus, you want to use any feedback that you get. If you send it to the first 10 VCs and they say, interesting, but you're a little weak in management, you want the opportunity to tweak your business plan so when you go to the next round, you address that issue. So the terms that you worry about in a term sheet from VCs, the biggest is valuation. What is the price they're going to pay for your company? So what they do is they determine a pre-money valuation for your company, and all that means is the value of the company before the money goes in. That's why it's called pre-money. And what you do is you look at the number of shares that are outstanding. They always require that you have available options to grant, usually 18 to 20%. A lot of that depends on who still needs to be hired and how many people are already at the company. And then they pick a price. And people ask me all the time, well, what's a typical price for a startup? There is no such thing. It's what a willing buyer will pay. It could be $1 million. It could be $3 million, $10 million, $15 million. It really depends on what the product is, how far the company is, what the management is, are they experienced, what the market is. So at the end of the day, the price is what someone will pay. So the best thing is to have more than one term sheet. That's the best way to raise the price. And term sheets will come in with wildly divergent valuations. So it's important not to spend too much time thinking about what your value is going to be. And you always want to try not to put the value on the table first. You want them to put the value on the table first. But the best thing to do is to go out there and see what the interest is, see what the term sheets look like, and see what the values are that people are putting on the table. And then to determine the price per share, you take all the shares and the options beforehand. You divide them by the pre-money price. So if the pre-money price is $5 million and you had 10 million shares, then the per share price is 50 cents. And then what people refer to as the post-money valuation, so if you had a $5 million pre and you raised $5 million, your post is $10 million. It's pretty simple.
What determines the number of shares that you have to start with?
The question is, what determines the number of shares to start with? It's really the number of shares you decide to issue. So usually you would issue shares to the founders, and you would create an option pool for employees. You might have shares issued to your directors and advisors. And a lot of how many shares are issued depends on how many people you have in the company and how far along you are. And what you try to do is issue a number of shares so people are comfortable with it, but you don't end up with too many. And it's kind of silly. If you give someone 100 shares and it's 1% of the company, or you give them 1,000 shares and it's 1% of the company, they have the same thing. So they should be equally happy, but that's just not the way it works in life. People feel a lot better getting 1,000 shares. So there's a lot of grade inflation or share inflation in startups. But you want to be careful that you don't issue too many, because if when you ultimately go public, you have too many shares, you have to do a reverse stock split. And that means if you did a 2-for-1 reverse stock split, you take every 2 shares and you give the person 1 back. And even though, once again, after the stock split, everyone still has the same percentage of the company, somehow they just feel like they lost half their value. So it's not mathematically possible, but it's the way people feel. So how many is too many? Well, at the end of the day, when people go public, it matters most when you go public, although sometimes people will just do a reverse stock split because there's just too many shares out there and it's just becoming unwieldy dealing with it. We usually say if you start out with the founders getting between 3 and 6 million shares divided among them, depending on how many there are. If there's only 2 founders, we'd say 3 or 4 million. If there's 4 or 5 founders, we'd say maybe up to 6 million. And if you divide that among the founders according to the percentage that you agreed to divide up the company, it usually ends up being about right. But a lot of it depends on how many rounds of financing you do and what the price is. So you can never really know. I've seen people show up and they've scheduled out how much the founders get, how much they're doing in their Series A, B, C, D, and how much they'll all have when they go public. And the only thing I can tell them is that the paper's wrong. You can never figure out in advance how it's all going to play out. But if you kind of start with that as a rule of thumb, it usually works out okay. So now you've gotten your valuation, and you've you have to figure out how much money you want to raise. You also have to figure out how much money people are willing to put into the company. And what you want to do is you want to make sure that you raise enough money to get to the next stage.
Question. What's the legal for a legal corporation? How much do you have to distribute?
That's a good question. How much stock do you have to distribute? The good thing about stock is you can just make as much as you want. You file your certificate of incorporation with the state and you say how many shares you have, and if you run out, you can make more. You just amend it, but it needs board and shareholder consent. One person can hold all the stock, and also you usually have what's called authorized but unissued stock. You might authorize 10 million shares and initially only issue 3. So it's kind of whatever you want it to be. So you have to figure out how much money you want to raise, and you want to make sure it gets you somewhere. If you say, well, I only want to raise $2 million now because I don't want too much dilution, but at $2 million you hit a wall. You haven't reached another milestone. You haven't got your product out. You haven't had enough to hire enough people or to get sales or customers. So you have to balance the desire to not have too much dilution with the fact that you need to make sure this round gets you somewhere. Because if you raise money and you run out before you've gotten somewhere, your valuation will decline. And that's not what you want to have happen. And also the investors are going to ask you that. They're not going to want to put money into a company that's not going to get them where they want to go. So you need to make sure that when you ask for what you want to raise, you've thought through how you're going to spend it, how long it's going to last you, and what you believe you'll have at the end of that money. You also have to keep in mind that when you run out of money at the end, it's going to take you another 3, 4, or 5 months to raise it. So you're going to have to start raising money before you run out, but it's hard to raise money if you haven't reached the next milestone. So let's say you're raising $5 million. Sometimes you'll get the $5 million all up front. Often you will. But what's become a common thing that VCs are doing these days are having milestone-based investment. So they'll commit that they'll put $5 million into your company, but they'll say, I'm only going to give you 2 now. And when you get to this next milestone, I'm going to give you another 1. And when you get to the next milestone, I'm going to give you another 2. Ideally, as an entrepreneur, you want to avoid that. If you can't, then you want to make sure the milestones are very clear, very attainable, because you've gone to all this effort to get this $5 million theoretically. You want to make sure that you actually get it, and not that you find yourself $2 million from now out raising money again. Also, stock will issue dividends. It usually says 8 to 10%. That's a provision that's always in a term sheet. It's a provision that's basically a throwaway because no startup company ever issues dividends. So the next really important provision is the liquidation preferences. And what that means is who gets paid what on the liquidation of the company. And sometimes people think of liquidation and they think of what normal people think of when you think of liquidation, basically bankruptcy. You see the signs on the stores, liquidation sale, going out of business. But in this context, liquidation is a sale of the company. So this is how much people are going to get when the company is sold. You don't really care how much people are going to get when it goes bankrupt because there isn't anything to pass out. So the preferred stock, the VCs always purchase preferred stock, and it always gets its money out first. And if you put in $5 million and you get $5 million out, that's called a 1x liquidation preference. It's 1 times your money. That is the norm that the preferred investors get 1x their money back first. Sometimes you will see that they get 2x or 3x, but the most common is 1 time your money back. If there's more than one series of preferred, sometimes there's a question of seniority. Does the B get their money back before the A? Do the A and the B get their money back at the same time? Those are things that are negotiated as the various rounds of financings move forward. But then the big question comes, what happens after the preferred gets their 1x back? Sometimes you say, okay, they get their $5 million back, and then everything else is shared among the preferred and the common. That's called fully participating preferred, because not only do they get their money back, but they participate in everything else. Then there's participation with a cap. So they get 1x their money back, then they share with the common until they've gotten a total of 2x or 3x or 4x, whatever the negotiated term is, and then the common gets everything that's left. As an entrepreneur, you want to negotiate for something like that because you want there to be some threshold at which you sell your company that you're getting your proportionate interest. So the way that works is, let's say the preferred holds 50% of the company and the common holds 50% of the company. And you raised $5 million. I'll see if I can do the math. And you sell a company for 30. And the preferred has a 3x total liquidation. So the first $5 million goes to the preferred. Then there's $25 million left. That's shared 50-50 between the common and the preferred. So the preferred would get 12.5, and the common would get 12.5. But since the preferred has a cap of 3x, and they put in $5 million, they would only get $15 million. So in that example, they're getting $17.5 million. So after they get $15 million, they don't get that additional $2.5. It goes to the common. And it's a complicated formula, but there will be a point where, so in this example, probably at $30 million. So at $30 million, the preferred would not do anything, because whether they get their $15 million under their preferences or they get half of $30 million, it's still $15 million. But if the price were 35, half of 35 is higher than 15, so they would say, okay, forget our preferences. They can choose to do this. Forget the preferences. We'll just take 50% of the pot. And that is where, as a common holder, you want things to be, because if you own 50% of the company, you want to make sure you get 50% of the sales price. So I know that's a little confusing, but that's sort of an overview of that.
For Series A, what's the normal X?
For Series A, what's the normal X? Sometimes it's 1x off the top and then participate for another 2x for a total of 3x. That's probably one of the most common. Sometimes, though, the savvy Series A investor will only ask for 1x off the top, because the Series A is usually sold at a much lower price than future rounds, and they're trying to set a precedent. And they want the other investors to come in with only 1x and no participation, because if you look at how it plays out, the Series A will usually do better that way. But I would say it's still probably more common to have some participation.
So were you implying then that if someone invested $5 million, they'd be capped at $2 million return on that if it was sold?
Well, they have, if they stick with their liquidation preferences, so it's an either-or choice. If you have preferred stock that has a 1x participation and gets to participate for another 2x, once they hit that number, they stop sharing. But they can always choose to convert to common right from the start and get more if it yields them more. So they have a choice, but they can't do both. They can't take their $5 million off the top and then share forever up to 50%. So what you want to do is you want to force an inflection point where they have to pick between the two. Any other questions on that?
Can I ask you to go back to milestones? Is that all right?
Sure.
I'm just wondering sort of what metrics are usually used to determine these milestones, who gets to decide whether a milestone is met or not, and what happens if a milestone is missed?
Okay. Who determines the milestones? What do they tend to be? Who figures out if they're met, and what happens if they're missed? So they're usually determined in a negotiation of the term sheet. And the investor will usually say to the entrepreneur, you know, what are your plans? And then they will use those against you. You will tell them what you think you're going to accomplish, and then they're going to set those as the milestones. And what the milestones are really depend on the business. You know, a software business versus a chip business versus a restaurant business is going to have different milestones. But basically, it's usually sort of the next step in the process. And who determines if they're met? At the end of the day, it's really the investor. You could fight over it, and if they disagree and don't part with their money, you could sue them for breach of contract. But that's not going to really help you much. So usually at the end of the day, the investor is going to pretty much have a free hand of deciding whether or not they're met. So what we advise our companies is to make sure the milestone is written in such a way that somebody off the street who doesn't know anything about your business can come in, read it, and figure out if it's been met. You don't want it so complicated that you need an expert in the field to even figure out if it's met. The more simple and straightforward it is, the more chance you have that there's not going to be a disagreement about whether or not it's met. And then if it's missed, it really depends on the terms. Sometimes it says, okay, so they gave you $2 million, they give you another $1 million at the next milestone. You missed that milestone. So they may agree to extend it. Well, when you get there, I'll give you the $1 million. Or they may say, that's it. Or they may say, okay, when you get to the second million or second milestone, you'll get the $2 million for that milestone plus the $1 million from the milestone before. So it's really completely a contractual negotiation. But you would hope that they would say when you finally get to that milestone, they'll give you the money because you probably need it to get to the next milestone.
But it's not typically the case that missing a milestone results in everybody sort of throwing their hands up in the air and leaving negotiations.
So the question is, does it usually lead to people just saying it's over? Usually not, because you already have $2 million of their money, and they want to see you succeed. Unless they determine that you missed the milestone and it's really proving that this business model just isn't going to work, that you all made a mistake in assuming it would work or that it could be done. But usually they're willing to work with you because you already have part of their money, and so they want to make things work out. They might negotiate a higher price. They might change something like that.
I have a question about talking to VC in general. The VCs, I heard they don't sign NDAs.
Now, the question is, do the VCs sign NDAs? The VCs do not sign NDAs. No.
So, I mean, what should we do? I mean, these kind of discussions are very in-depth and people get into technology details.
They do.
If they don't end up investing, then they walk away with a lot of our information.
That's true. The VCs usually don't sign NDAs because they see so many plans that they don't want to be in a loss. And there's so many companies doing the same thing or trying to do the same thing, and they don't want to put themselves in a position where they're in a lawsuit saying that, I met with you, you stole my ideas, and then you finance this company and use them. On the other hand, you as an entrepreneur have to protect yourself. So you have to strike the balance between telling them enough to get them interested, but not disclosing the crown jewels. And it's a very fine line, and it's a very difficult balance. And so what you do is you really try to not tell them everything until you're really pretty sure they're going to invest. But you still have to get them interested. So it's a difficult balancing act.
So further question on milestones. How effective have you seen them to be? I mean, on one hand, do they help investor and entrepreneur bridge the valuation discussion, or do they just create a controversy later on because they can be ambiguous within a small group?
So do milestones help bridge a gap, or do they just cause constant problems later on? I think in general, they help get financing, because usually when a company's in the position of having to agree to milestones, it's the only way the investor is going to put money into the company. They think it's a pretty good idea, but they want to see certain progress. I think it can, if the milestones are well done, they can really help keep the company's feet to the fire and help them make good progress and help them motivate their troops. But they also can be very problematic. So I think, in general, it's ideal to avoid them because it's just one more complication and stress. But I think if you have to do them and they're done right, it usually works out okay. I've rarely seen it just become a big battlefield.
What about the situation where things change, plans change, and things, the market changes, competition ever ends, and you change the milestones?
So what happens if the market changes, anything changes, and you have to change the milestones? You have to go back to your investors and renegotiate that. And that's another reason to avoid milestones as you can, is because things almost always change. But hopefully the investor still believes in the company, they believed in it enough to put their money in the first place, and hopefully they'll be reasonable and negotiate a new milestone. But that can be a complication.
Is there ever liquidation preferences for the angel investors? And if so, how does it impact VCs coming in?
Do the angels ever have liquidation preferences, and what's the impact on the VCs? If the angels do a Series A round, they would have liquidation preferences just like a VC. And unless the angel liquidation preferences are so out of whack, the VCs usually just follow along, and it's not troubling. Sometimes they will ask to be senior, so they'll say, if you're senior, then the Series B gets its money out first. Let's say the Series B put in $10 million. They get the first $10 million. Then the A would get its $5 million. And then, I'm breaking things up here. Then the sharing would begin. So as long as if the angels have done something like, 5x off the top and full participation, the VCs would probably say, unless that's amended, we're not putting our money in. Because the VCs also want the common to be motivated, because those are the employees, and those are the people who are going to ultimately make the company and the product work. And if there's so much liquidation preference ahead of the employees that they don't ever feel like they're going to get any money, they're not going to be particularly motivated. So the next provision usually found in a term sheet is the conversion. At what time does the preferred stock have to convert? And Usually you can convert your preferred at any time at your choice. You have to convert if usually a majority, sometimes 2/3 of the other holders of your series convert. And then there's usually a threshold on an IPO where you want to convert, and that's where it's most important, because you can't take a company public with common and preferred stock. It's just not a structure that works in the U.S. public markets. So you want to make sure that when it's time to do your IPO, that all the preferred have to convert. Now, on the other hand, the preferred are going to want to make sure that it's a good enough IPO that they have to convert on. They don't want to convert if you're going public on the pink sheets. So usually you negotiate a price. Depending on what round it is, it's a different multiple. So if it's maybe the Series A round, it has to be 6x the price they paid. If it's the Series D round, maybe it's 1.5x the price they paid. So if you're going public at a price where their stock will be worth that value, and you raise at least 20 or 30 or 50, whatever the negotiated amount is in your IPO, then everyone is forced to convert. So that's an important term, especially for later rounds, because you want to make sure, certainly in companies that went public, when the bubble burst or shortly after that, they were in a position where maybe the conversion price was $12 a share and they were going public at 10. So they couldn't force their preferred to convert. So they got into negotiations with the preferred, and they're about to go public, people see money on the table, and often companies were held up in order to get the preferred to convert. So that, although it seems very unimportant, you're just starting the company and you're worried about what price you're going to go public, it is something to think about, because if it is the type of company that you think you're ultimately going to take public, then it's important. If it's a company where you think your most likely exit is a merger, it's much less important. Then there are protective provisions, and what those are specific things that the preferred get to vote on. So they would be things like you can't sell the company without our permission. You can't issue additional preferred without our permission. You can't borrow money without our permission. You can't change your business line without our permission. So some things are very standard. Not being able to merge is pretty standard. People fight over whether they can issue additional preferred. You usually want to say, okay, I can't make someone senior to you, but I can at least sell some preferred without your permission. Things like getting into whether or not you can incur debt or change your business line, those are really decisions that should be made by the board of the company and not the investors. So what you want to do is be careful there that you basically don't have your company hijacked by the preferred stockholders and have to go to them every time you want to make a significant decision. Then the other thing you want to be careful of is what's called a series vote. So classes of stock, common as a class and preferred as a class. And then a series, there's Series A, Series B, Series C. What you want to try and always have it be is that the preferred as a whole votes. Okay, I need a majority of the preferred to sell my company, but I don't want to have to get a majority of the A and a majority of the B and a majority of the C, because that just increases the number of people that you have to go to, the number of consents you have to get. So what you want to do is not have too many other people deciding what the company can do. You want the board to be able to make decisions, and as long as basically a majority of the shareholders go along with it, you want the company to be able to move forward. Then there's also anti-dilution protection. What a lot of people think this means is that if you issue stock at a price less than I paid, I get more stock. And that's not how it works. How it works is when we sold our Series A at $1 a share, it usually starts out at a 1-to-1 conversion. So 1 share of Series A converts into 1 share of common. If you have anti-dilution, it will change the number of shares of common that the Series A converts into, but it's not going to change the number of shares of Series A you get. And there's basically two methods of anti-dilution. One is called full ratchet, which means if I paid $1 for my share and you issue so much as one other share at 50 cents, my conversion price just became 50 cents. That's pretty draconian because, one share, 50 cents, and the whole thing moves. So what's more common is what's called weighted average anti-dilution, which is where you take, you look at the number of shares that are outstanding, you look at the price that you're selling the shares at, you're looking at how many you sold at that price, and you're doing basically a weighted calculation. And what this means is that, so if you've had anti-dilution kick in, and the Series A that used to convert 1 for 1 now converts 1.2 for 1 or 1.5 for 1 or 2 for 1, they have more votes when you're voting on things as a whole, And when you actually pass out that money under those liquidation preferences we talked about, they're now going to have a bigger percentage of the company, and they're going to get more of the money. So you want to be careful that you don't agree to anti-dilution provisions that are too strong, because you may in the future have to raise money at a lower price. The investors will usually want a right to participate in future rounds of financing. That's a pretty standard provision, and there's usually not a lot of negotiation about it. What you want to be careful of is that they can only buy their proportionate share. Sometimes they say, I want to buy 1.5 times my proportionate share. And what you don't want to do is, if you want to bring in fresh blood into the company, you want to bring in an outside investor, you want to make sure that the existing investors can't take everything that's available. There's often what's called, you may have heard of a pay-to-play provision. And what that says is, so I invest in the Series A. If I don't invest my pro rata share on the Series B, my Series A stock converts into common. As an entrepreneur, you don't care. You're thrilled, actually. There's less Series A out there with liquidation preference. If you're on the investing side, you may say, well, I'm willing to part with my money now, and I want to keep my investment. I don't want to have to perpetually be obligated to put money into this company or lose my stake. So that's something that's usually asked for by the investors and not by the entrepreneurs. Redemption. Sometimes investors will say, if you haven't had an exit event in 5 years, I'll get my money back. Now, that really kind of goes against the concept of venture capital. It really makes it more of a debt instrument. But at the end of the day, you probably don't care, because it's usually far enough out that if you haven't had an exit event, there's not going to be any company or any money left to redeem the stock. So if you're forced to have a redemption provision, you usually want to make sure that it's far out in the future. There's drag-along rights, and what that means is that that's a nice thing for an entrepreneur to have. Basically, that says if 50% of the stock, or 51% you want a majority, agree to sell the company, everybody else has to go along. And that helps to sell a company when the majority want to do it. What you want to be careful of as a founder is sometimes they will say if a majority of the preferred want to sell the company, all of the common has to go along. And since, as you've seen in the liquidation preferences, that often the preferred might be getting money when the common isn't, you don't want to lose your vote on a merger. So the pay-to-play provisions, the drag-along provisions are often hotly negotiated among the common stock and the preferred. They're usually not too heavily negotiated when it's preferred dragging preferred. Registration rights, they're very complicated, they're very long, they're seldom used. I'm going to kind of just mention those. What they are rights to have your stock registered in the future when the company goes public. A co-sale agreement usually is imposed on the founders. What it says is if a founder wants to sell their stock, that the investors can sell a proportionate share. So let's say a founder wants to sell 1 million shares of stock. They have to tell all the investors that they want to do this, and the investors can all sell a proportionate amount. Basically, the concept is the investors don't want the founders exiting the company and leaving them behind. It doesn't happen that much because there's just not really much of a market for private company stock. But it's something, as a founder of a company, you should understand that you're just not free to sell your stock when you feel like it. Now, one of the important things in a term sheet is a no-shop provision. Term sheets are usually not binding. So a VC will give you a term sheet, they will sign it, you will have negotiated heavily all of the terms, and they are still under no obligation to finance your company. They don't have to do it until the final agreements are all signed. But what they will try and impose on you is what's called a no-shop, and that will be binding on you. And what you'll agree is for some period of time, you won't go out and talk to other investors. So you want to be aware of that. It's a pretty common term because the VCs don't want to invest the time and effort to move forward on the financing. They don't want to put a price on the table and have you go shop it. But what you have to understand is that you're committing to something and they're committing to nothing. So you want to make sure that if you do sign a no-shop, it's for a very short period of time, maybe 2 weeks, maybe a month, but you want to make sure that either they've signed up to really give you the money or you can move on. So our handouts, I have a form of term sheet. And then also I wanted to talk for a few, sorry, question back there. Well, until you sign the term sheet with the no shop, you can talk to anybody you want. So if you have 5 term sheets that show up, you can negotiate with each of them. But at the time that you sign the term sheet, then you have to stop talking to everybody else.
So you really don't want to sign unless you really agree to it.
You don't want to sign the term sheet, until you're comfortable with the terms and until you're willing to take yourself basically off the market. I mean, if it's a 2-week lockup, probably not that big of a deal. You're probably willing to sign the term sheet and hopefully go forward if you generally like the terms. If it's a 45-day lockup, you might feel a lot different about that.
Can you advise clients against certain rights to participate and the ability of investors to sort of hold the company hostage? So if the Series A investor has the right to participate and doesn't want to invest, is that going to make potential Series B investors not want to invest because of the information? What does the Series A investor know about this company that they don't want to participate in this round?
So does having a right to participate possibly harm you in future rounds if a Series A holder who has a right doesn't participate? That event hurts you. If you're trying to raise a B round and your A investors aren't interested in participating, the B will definitely ask why. But it doesn't really matter whether they have a right to invest or not. Even if they don't have a right, if they're not interested in reinvesting, they want to understand it. Now, if it's if it's an individual who doesn't have a lot of money, they'll understand. If it's a venture fund who's out of money, the fund is finished, they'll understand. But if it's a venture fund who usually does follow-on investments and isn't interested, it can cause problems.
Can you talk a little bit about the due diligence process, what that involves from your perspective, how entrepreneurs can handle that better or worse, more effectively, less effectively, how to prepare for it?
Okay. So how do you handle the diligence process, what to expect, how to handle it effectively? Basically, the standard of diligence in the VC industry has gone way up. The VCs spend a lot of time doing diligence. They really want to turn over every stone and really understand the company. So I think, first of all, like we talked about earlier, you should keep the crown jewels till last. You should keep the customer calls till last. The VCs will definitely want to call the customers. You'll want to limit them to maybe 2 or 3 if you have customers. And you don't want them to call every single customer. You don't want a whole bunch of VCs calling all your customers because you don't want to annoy them. And I think it's really important to give them, mark things confidential, give them copies of what you're going to give them, and keep track of it. Because I think a lot of entrepreneurs find that they get asked for the same thing over and over and over again, and it's very frustrating. So ask the investor up front, give me a list of what you want to see, and then compile the documents and give them to them. And also avoid extensive due diligence until you're pretty far down the road with the investor so that you know that you really think you want to proceed with them and so you believe they're really going to put a term sheet on the table that you're comfortable with. They're going to want to do a certain amount of due diligence before they give you a term sheet to make sure they're interested. But you have to balance that with giving them too much. And then there's usually business diligence and legal diligence. The legal diligence it's usually the easier side. That's pretty much all the documentation that forms the company and the contracts. They're going to want to know, is there any acceleration or severance payments or patent lawsuits. Then the business diligence is much more technical. They're going to want to talk to the engineers. They're going to want to talk to the people who are running the company. And as an entrepreneur, as hard as it may be to find the time, you really want to be present in most of those meetings. You want to know what your team is saying to them. You want to be there to correct any misconceptions right from the start. You want to be there to protect sensitive information if you need to. Any other questions on that? Okay. So one of the important things in a financing is who's on your board of directors. At the end of the day, it's really all about money and power. So we talked a lot about the money. We talked about the valuation. We talked about the liquidation preferences. We talked about how the money comes in with milestones. So then you look at, okay, what makes up the power? The power is in the protective provisions that we talked about, who gets to vote on what, and the power is at this table. That's the power of the company. The board makes the decision to hire and fire the CEO. The board makes the decision if you're raising additional funds. The board makes the decision if you're selling the company, if you're going public. All the major decisions in a company's life first has to be made at the board level. Now, the shareholders may have to approve that decision, but they can't start the process. So you really want to pay attention to the board structure. And one of the things a lot of people do is they spend a lot of time thinking about who is sitting in these seats. That's important, but what's most important is who owns these seats. So in my picture here, you have the founder, the CEO, a Series A director, a Series B director, and an outside director. Boards are almost always an uneven number to avoid a deadlock. The problem with the even is there could be a deadlock. It doesn't really happen that often. It depends on the makeup of the board. If you had 2 founders and 2 investors on the board, you very likely could come to a deadlock. If you had 3 founders and 1 investor, or 3 investors and 1 founder, it's less likely. But generally, boards are an uneven number just to avoid the possibility of a deadlock. So the question is, would you bring an extra person just to make it an odd number? Actually, you quite likely would. It depends. If there's 2 founders and 2 investors, both sides probably want to bring a third outside party so that there can be some balancing if the parties disagree. And you don't have to. There's sometimes boards which have 4 or 6, but it's common that you would. You'd certainly want to look at the composition of the board and decide whether you think it would be a benefit to have that extra person to make it uneven. Yeah. So later you get another round of financing. Do you have to ask someone to leave? Sometimes the board will increase. Depends on how many you had to start with. If it's getting too large, then sometimes you will ask somebody to go. But it depends on what the rights are. So in my picture here, so the founder is sitting on the board. The question is, how is the founder sitting on the board? Is the founder sitting on the board because he or she has a right to be there always, or because he or she was just initially elected and no one's removed them yet? So the way the founder would have a right to be on the board is the certificate of incorporation would say that the common stock gets 1 board seat. And then you could even have a voting agreement that says, every common stockholder agrees that these 3 people can name who sits in that seat. Sometimes it's the founder. It depends on how much stock the founders have. If the founders have enough to control the common, then you don't need to do that. But if not, or if they're worried about issuances in the future, then sometimes you have a voting agreement. And then we have the CEO here on this end. So usually when you start the company, one of the founders is the CEO. So you may say, okay, well, the founders have 2 seats here. They may or they may not. Sometimes the common will have 2 seats, and in this instance, the founder's the CEO and the yellow guy at the top is the founder. Or it might say the common have 2 seats, one of whom will be held by the CEO. And initially you think, well, that's fine because my co-founder's the CEO. But you have to understand, if your co-founder's not the CEO anymore, he has to leave the board, and the new CEO that is brought in is going to take that seat. And usually when there's a new CEO brought in, that person has been picked by the board, which is usually in the investors. So there's a swing in the balance of power of who controls that seat, if that seat doesn't belong to common but belongs to the CEO. Then we have the Series A director. The investors will almost always ask for a board seat. Sometimes they ask for 2. Depends on the structure of the company. It depends on the round of financing. So in this example, we have the Series A round, they ask for 1 seat. The Series B round, they ask for 1 seat. And then there's an outside director. Usually, once again, that's mandated in the financing round as to what the composition of the board will be. And then the question is, who elects the outside director? So usually, to start with, everybody agrees on who that person is. But once again, you want to look behind it and say, okay, if that person leaves, who controls that seat? And sometimes they'll say, well, it's everybody voting together, common and preferred voting together, so it's a dual seat. That may or may not be the case. Usually, one of the 2 classes of stock has a majority of the stock of the company. So if you say the common and preferred voting together elect that outside director, what that means is a majority vote of the stock of the company elect that seat. So if the preferred have a majority of the company, they get that seat too. So in this example, this could be a balanced board. It could be 2 founders, 2 investors, and an outside person. That's a fairly balanced board. Nobody clearly has the control. Or it could be a completely unbalanced board in that it could be the CEO who was elected by the VCs and an outside director who's elected by the stock at large, which the VCs control. So they might actually control 4 seats. So just by seeing who's on the board doesn't really tell you who controls the board. So it's something you really need to get behind, you really need to understand, and you need to figure out where the balance of power is. At some point in the life of a company, the balance of power always shifts to the investors. But the question is whether it's the A round, the B round, the C round. A lot of it depends on the company, the negotiating power, and who the investors are. But what's most important is just that you understand who can fill those seats. Allocation of who can vote for them or what they're paid? Oh, so the question is, what is an outside director typically paid in stock to be on a board? That really ranges, but it's maybe about 1/4 or 0.5%. It depends on if they're a luminary in the industry, they might get more. If they're not, they'll get less. Any other questions on the board structure? Okay. Then I wanted to kind of show you guys sort of examples of dilution of a company as you do each round of financing. So this is taken from a real company. When they did the Series A financing, 47% of the company, this is so immediately after the A closed, 47% of the company belonged to the Series A, 45.6% belonged to the common, and 7.25% was reserved for options. Then they did the Series B, and you'll see that the common went to 34, and the options went to 10. You say, well, how did that happen? What happens is in connection with the Series B financing, the investors will say, you need to increase the option plan before we put money into the company because we see that you're going to have to hire more people or refresh options or whatever, and we want to see more into that pool. And the Series B was 20.4%, and the A was 35%. Then the Series C happened. We've got the options at 22%, so they refreshed again quite a bit. The common is at 32%, so they held pretty steady. And part of that, you might say, wait a minute, the math doesn't work here. Part of what happens is the options are exercising. So some of the blue is moving into the common, and then the options are getting bigger. So yeah, when you look at it, you say something's wrong. But that's what happens is the common got bigger because the options converted, and then they made a bigger pool and refreshed it. And then the Series C was 21%. Then a down round occurred. So major washout. The D comes in. Everyone else got completely crammed down. The D has 98% of the company in this scenario. I just threw that up there for interest. And then the company went public. And they actually did pretty well in the public offering. The common had 65% of the company. The IPO shares were 25% of the company, and the options were 9%. So at the end of the day, even these people who were crammed down really far ended up doing quite well. That's not normally the case. How did what happen?
Yeah, you said like in the after Series B, right? All like the common only have a tiny portion, but
Oh, because all of the A, A1, B, B1, C, C1, and D all convert into common at the IPO. So we were talking earlier about what the thresholds are that force people to convert. So they all became common. So in this picture, the purple is basically all of the stock of the company that existed before the company went public, whether it was preferred or common. And that's one of the benefits of going public is these liquidation preferences no longer matter. Everyone's now on the same playing field. Everyone has common stock, and it's all at the same price. Any other questions?
In that first Series A diagram, nobody has 51%, so what happens in voting?
You have to get 51% somehow. Actually, the numbers, options don't vote. So that 7.25% isn't going to have a vote, so someone would have 50%. But if you don't, then you just, you need to get some of the other camp. If it's an issue that's of particular interest to the common, they'd have to convince some of the preferred to do it, or vice versa. Okay.
When they went IPO, am I right, the 98% of the 65% of the common went to the investors?
Yes. Because they had 98% of the company. Yeah. Yeah. In this situation, the price was high enough that everyone still did well, but you're right, it wouldn't normally be the case. Any other questions on this? Okay, the last I wanted to talk about briefly, is a corporate investor. So what that is rather than a VC coming in, sometimes a company that you're doing business with will be interested in investing in you. And lots of the major corporations have their own VC arms, and they will do some sort of an investment. Usually, corporate investors give higher valuations. They are not as picky as the VCs. They don't do this. This isn't their main line of business. And so that looks pretty good. But there's some drawbacks. One of the positives still for a corporate investor is they tend to have less day-to-day involvement. They're probably not micromanaging your company as much. Sometimes they don't even want to sit on the board. Sometimes they just want a board observer seat, which gives them a right to come to board meetings but doesn't give them a right to vote. So largely with corporate investors, you maybe get a higher valuation and you get less day-to-day involvement. The downsides to a corporate investor are that they may have conflicts with customers. So your first customer is great and they want to put $5 million into your company, but then your next potential customer is their arch rival. And they say, I'm not going to become a customer of a company that's owned 50% by my arch rival. So you have to be really careful about that and think about whether taking money from this corporate investor is going to hurt your opportunities to get customers in the future. There can also be significant conflicts on an exit. So a corporate investor usually doesn't invest in a startup company to make money. They're usually making money through their line of business. They may be investing in it for a first look at new technology or things like that. So you may ultimately want to sell, and they're not interested in selling because they like you being their supplier. Or you may want to sell, once again, to their arch rival, and they don't want the arch rival to have the technology in your company. So you have to keep in mind, if you're talking to corporate investors, that there are pros and cons to it. The terms are usually the same as the ones we talked about before. It's, they still do a Series A or a Series B round, which has all the similar terms that we talked about in a VC financing. But these are just some of the issues to think about with a corporate investor. So 3 things to remember from tonight. First of all, you need to spend some time determining the type of financing that makes sense for your company. Are you going to bootstrap for a while to get to a point? Maybe a bridge loan, angel financing, VC financing, corporate investor. But keep in mind, you need to get enough funding to get you to the next step. You should be sure you carefully understand all of the terms of the financing. Often you're so happy to get it and you're such a rush to do it that you don't take the time to really understand how it plays out and what it means for your future and for control of the company. For instance, corporate investors sometimes ask for perpetual licenses to your products. So you want to be careful that in your exuberance to get money, you don't sign away your future. And lastly, you should balance dilution with time to market. People always want to make sure they don't give away too much of the company. So I'll only raise $2 million now while my valuation is lower. Then I'll get to a point where I can raise, $5 million at a higher valuation. That's a great strategy for minimizing dilution. But if you're a type of company where time to market's important, maybe you don't have a huge lead on the others, maybe there's not a lot of barriers to entry to the company you want to start, it might be worth suffering more dilution to get the money so you can get to market, because 20% of something's better than 50% of nothing. So that's a mistake people often make, is trying to dribble out the financing too thinly sliced to minimize dilution, and they miss the market opportunity. So that's it. Are there any other questions?
Can you talk a little bit about the details of bootstrapping in terms of how money is put in, how that's all determined, what the legal aspects, what decisions need to be made?
So some of the details of bootstrapping. Basically, a lot of it depends on how many founders there are and if everyone's putting in equal money. If you're the only founder and you're using your own money to get your company started, It's not really that complicated. You don't need to draft up a lot of documents. And you usually don't just keep issuing yourself stock every time you put a loan into the company because you already own most of the company. If there's more than one founder and one founder's putting in all this money because they have it and the other founder's not putting in much money because they don't or they're not willing, then you really do need to figure out among the two founders what the deal is, what the person who's putting in the money is going to get for that. Are they going to get more stock? Are they going to get a bridge loan that will convert someday if you do another round of financing? What's the deal? So that's the important thing to think about. What can often happen is people can have advanced a lot of money to the company without talking to their partner ahead of time to figure out what the deal is, and there can be conflicts. And once the money's in the company, it's there. You can't really get it back.
Yeah, if you're financing a company through bootstrapping and you're using your own personal credit card to pay for expenses, how do you deduct that from your personal income tax?
You have to talk to an accountant about that one. How do you deduct expenses of the company from your personal income tax? I'm not sure if you can, but that's something you'd have to talk to them about. It might be an expense of the company.
Is there a time between series? Like, usually it has to be at least a year.
How long is a typical time between series? It really depends on the company and what the next milestone is. Usually wouldn't be doing financing 3 months apart or even 6 months apart. If you think about the fact it takes usually a minimum of 3 months to raise the money. But it could be anywhere from 9 months to 2 years maybe.
What's the typical or like a realistic goal for a founder to have their percentage of equity at the time of IPO? So
What's a
what's a realistic goal?
realistic percentage for a founder to have at the time of the IPO? That's pretty tough to answer because it completely depends on the history of the company, how long it took you to get there, how much money you raised along the way, what the valuations were. In our pie charts I was showing, the founder was looking pretty good until they had to do that final round, and then everybody got slammed. So it's really all over the map. I'm sorry, back there. I didn't see you. So how strong and legally binding is the term sheet, and does it evolve over time? It actually is pretty strong, and the term sheet isn't legally binding, but then all the documents that are drafted off of it are. So all the terms are really pretty much set in stone. They may evolve over time if something happens and they're renegotiated, but usually not that much. So it is pretty much whatever you're getting yourself into, you are legally bound with. It may change when a future investor comes in and asks for a change, but there's usually not a lot of future negotiation between the VCs and the founders after the financing has closed.
What advice would you give to entrepreneurs who are bootstrapping when they need to obtain legal advice or engage lawyers as far as paying cash or considering equity or?
When does a bootstrapping entrepreneur need to seek legal advice? Well, as we talked about last time, you should form the company at an early stage, particularly if there's more than one person involved and if you're entering into contracts. If it's just you and you're using your money and you're not entering into a lot of contracts, you don't need to worry about hiring a lawyer. You're just in your garage developing your product. But if there's more than one person involved, you're entering into contracts, you want to make sure that in addition to the money you're putting into the company, you're not incurring additional liability. Then it's time to talk to a lawyer to at least understand the basics of forming the company.
And as you do that, have you seen, are there a lot of lawyers who do it for equity, or would you recommend just paying cash?
Usually you pay cash. There's some lawyers that do it for equity, but not that many because lawyers are conservative. Otherwise, we'd be starting our own companies.
And if someone hasn't done that before, do you have any advice as far as should be careful to get quotes ahead of time or manage the number of hours, or what are some mistakes that we might make since we've never done them before?
First of all, take a look on the website, and there's a questionnaire from last time about questions to ask your attorney. But you should definitely make sure it's like signing any contract. You want to know what you're getting for your money. You want to know what you're getting yourself into. You want to know the hourly rates, what you're going to be charged for, and that sort of thing. So, sorry, there's a question way back there. Did you have a question? When engaging a lawyer, what are the key things to be worried about? Run the other way. No. I think it's important that, like I said, you know what you're getting yourself into, that you understand their rate structure and how they charge, and that you're comfortable with the lawyer, and you feel they're going to be responsive to your needs. You want to make sure they've done startups before. You don't want them learning on your nickel, and you want to be comfortable that they've been involved with the kind of transaction you're going to get involved in before, and that they have some domain experience in the area you're going into.
So for the companies you've worked with that have done sort of the bootstrap mode, do you find that funding they put in is rewarded when they do finally go out to the public market, the Series A, with kind of the understanding that those are lean years or sort of?
Well, the question is, have I experienced that people who bootstrap are ultimately rewarded for those efforts at the end of the day? I think the people who've successfully bootstrapped, and so they've gotten their company to a place where they can get a higher valuation for the first round, usually if you track it as it plays out, they'll end up with a higher percentage. But once you do that first round and you get your percentage, the bootstrapping, from then on, it doesn't matter. So the real value in it is the first valuation you can get from outside investors. And that is where you weigh the money that you have and the time to market issues.
For someone who's putting in significant money in bootstrap, can they would they typically be able to succeed with saying that I want to be treated as Series A investors? Saying that money is Series A money from the put in earlier?
So if you put a lot of money into the bootstrap, what's the success rate of basically getting that converted into Series A stock? A lot of it depends. First of all, it depends on how much money you put in, and it depends on the valuation it ultimately gets you to. Often people will say, well, okay, now I'm investing in your company at a $5 million valuation, and that's basically your reward for the bootstrapping. I'm not going to let you have stock for that money on top of that. It's not a bad idea to keep track of it, to do some sort of loan or just write it down. And depending on how large it gets, what your initial valuation is and who your investors are, you may or may not be able to convert that into stock.
I noticed you didn't mention small business grants, things that come from the government. How important is having that repertoire of financing before even getting, in terms of seed money, before getting some of those early phases?
So the question is that I didn't talk about SBA loans and government grants and things like that. Certainly if you're the type of business who can get an SBA loan, who can get a DARPA loan, who can get some sort of a government grant, and you can use that to, in essence, bootstrap your business, that's a very good thing to do. You need to figure out if it's available to you. You need to understand the terms of it. And many times, if you can get it, there are very few strings, and it's a great benefit. But it's hard to get. Does it help attract? Well, certainly I think it does in that not the fact that you have an SBA loan helps you attract the next series, but the fact that it gets your company to a point where it's further along, so maybe you have customers or a beta product, so there's not as much risk. So basically it helps by where it gets you versus just the fact it exists. Is it better to take your money and buy founder shares in a bootstrapping than to try and get Series A? Founder shares are usually sold to the founders for pennies, not much at all. And you'll have those just by virtue of being a founder. So certainly to the extent that you bootstrap and you don't get any Series A for it, you can add that money to your basis. So when your stock is ultimately worth millions, you don't have to pay taxes on at least that amount. But it doesn't really make sense to just keep buying more and more founder stock because you're already going to have your percentage.
How often do you see mixed model investors in the sense that perhaps Series A corporate investor and Series B VC investors come in? What are the pitfalls of that model? For example, where the VCs keep pause.
So how often do you see a corporate investor maybe in an A round and then a VC in a B round? You see it often, and a lot of it depends on those issues. You asked if it would give the VCs pause. They'll have pause if they feel like the corporate investor is in a position to stand in the way of the company being sold, because VCs are about exit. They are, they ultimately want to make money off their investment. That's what they do. That's their obligation to their limited partners. So they will, if a corporate investor doesn't harm the company in any way, they'll be just as happy to invest. It doesn't trouble them. But if they're worried that it will hurt on exit or hurt in getting customers, it may hurt your chances. Okay, I think you've been.
Do founders ever get options as the company rolls along and goes through rounds?
Yes, they do. It depends on how long. It depends on how much the founders got to start with. It depends on how much they've been diluted, and it usually depends on what round you're at. But if you've gone through several rounds of financings, the founders have been diluted way down. It's not uncommon for the board to give what's called a refresh grant. So basically re-incentivize them by giving additional shares.
Do you see many examples of private equity buyouts coming in before an IPO, after venture capitalists? And if so, how are they determining the direction of the deal?
Do I see many private equity buyouts before an IPO? Not really that many in Silicon Valley. It's usually a sale of the company or an IPO. There's a lot more private equity buyouts on the East Coast. Behind you, sorry.
Is there any vesting of founder stock?
Yeah, there's often vesting, and I don't know if there's anything. I think there's a few notes in maybe the PowerPoint from last time. But the founders, VCs will always want vesting. As between two founders, you would usually want vesting because you want to make sure that one of you can't walk out the door and have all their stock while the other sits around and still works. So there's almost always if there's only you, you're not going to impose vesting on yourself. But if there's more than one person or if there's VCs, there's almost always vesting.
Can you have one founder, no vesting, and other founders?
You can. The VCs won't stand for it, but among the founders, if you guys agree to it, you could do it.
How much does the VC value the initial money you put into the company, or is the technology product outweigh?
They value the result. So the question is, how much does the VC value the initial money? The money, they don't care about. The result is what they care about. Any other questions? Okay, well, thanks for coming. I'll stay around for questions at the end.